There's that feeling, that stomach-churning moment. You get called into an office, they hand you an envelope and say, pack up your things. You're trying to read this letter, and you see words like cause or without prejudice, and your brain just shorts out. It's total confusion.
It's a complete fight or flight moment. And honestly, that confusion is exactly where the big mistakes happen. You freeze, you sign something you shouldn't.
Or you just walk away from rights you never even knew you had.
Exactly.
So that's what we're doing today, a deep dive into the very murky waters of wrongful dismissal here in Ontario. We're using a bunch of guides from HTW Law Professional Corporation to figure out what all this jargon really means.
And more than that, what the strategy is. The mission is really to organize the chaos. Because getting fired isn't just one legal event, it's a whole spectrum.
Right. And where you land on that spectrum determines everything.
It determines if you walk away with, well, nothing or a fair settlement.
Okay, so let's start with the big words. The terminology. I think most people hear for cause and just assume the employer holds all the cards.
That's the common assumption. But the HTW guides point out this massive distinction between, say, just cause at common law and willful misconduct under the Employment Standards Act.
And that's the key, isn't it?
That's the nugget everyone misses. You could be, just terrible at your job. They can fire you for cause. But unless it was actual willful misconduct, we're talking theft, punching your boss, something serious,
right,
they still owe you your minimum ESA termination pay. Just being bad at your job isn't a free termination for the employer.
But they use that cause label to scare people.
All the time. They're hoping you'll just walk away from your statutory minimums.
And this brings up a huge point about jurisdiction. Everything we just said applies to provincially regulated employees. But what if you work for, say, a bank or an airline?
It's a completely different ballgame. That's federal. You fall under the Canada Labor Code, and the term is unjust dismissal.
Which has much stronger protection.
Way stronger. And if you mix them up, try to use provincial rules for a federal job, your case is dead in the water before it even starts.
So step one is know your industry. Okay. What about this idea of constructive dismissal? This is for someone who hasn't technically been fired.
Right. Yeah, this is where the employer makes your life so miserable or unilaterally cuts your pay, basically trying to force you to resign.
Legally, that's the same as them firing you.
Exactly. The law sees it as a dismissal. And, the same kind of logic applies to probation. It isn't the Wild West that people think it is.
The probation myth. I was really surprised to see this. You can actually sue while on probation.
You can, because employers still have to act in good faith. They can't fire you just because they're being cheap or, for a discriminatory reason.
So if they act in bad faith,
the courts can void the probationary term entirely. Then you have full rights.
Okay, so let's say you think you have a case. The HTW law material really hammers this home. Knowing where to complain is just as important as the complaint itself.
It's a maze. And the forums are often mutually exclusive. You pick one, you can't go to the other.
So you've got the Human Rights Tribunal, the HRTO for discrimination.
You've got the Ministry of Labor for reprisals. And if it's tied to a workplace injury or chronic mental stress, you're probably looking at the WSIB.
The Workplace Safety and Insurance Board.
Right. And that's a trap. If you file with the WSIB, you are almost certainly locked out of suing in court. You don't get to double dip.
But if you just want damages money, you go to court. And this is where things just get really interesting with the update for October 1st, 2025.
Oh, this is a massive access to justice win. Huge.
Because the limit for small claims court in Ontario is jumping from $35,000 to $50,000.
Right. And before, if you were owed, say, $45,000, you were stuck.
You were in this legal no man's land. Too big for small claims, but too small to justify the insane legal fees of Superior Court.
And now that $50,000 limit solves that problem, you can use the faster, cheaper, small claim system for those pretty significant mid-size claims.
That's a real game changer. But, and this is a big but, there's the clock.
The clock is always ticking. And all these forums we mentioned have different deadlines.
Different clocks.
Yeah. WSI is usually 6 months. The Human Rights Tribunal is a year. The courts, generally 2 years. If you pick the wrong one and your deadline passes for the right one,
you could be completely out of luck.
You're barred from claiming anything.
Which really brings us back to the whole point of this deep dive. If you are staring at that letter, the one thing the HTW law sources stress is don't guess.
Get advice. Get it early. because choosing the wrong forum is a bell you just can't unring. Don't try to navigate that maze alone.
So, a final thought for everyone to chew on. If an employer fires you for cause, are they actually alleging real willful misconduct?
Or
Or are they just hoping you don't know that the small claims limit is about to hit $50,000 and you're too intimidated to call their bluff?
that is the $50,000 question, isn't it?
Thanks for listening to The Deep Dive. Stay curious and know your rights.